Good morning. Today is Friday, April 27th, 2018. This is an adjudicatory hearing before the Massachusetts Gaming Commission. My name is Steve Crosby. I'm the chair of the commission. I'm joined here today by my colleagues from my right to left, Commissioners Gail Cameron, Eileen O'Brien, Enrique Zuniga, and Bruce Stebbins. The entire commission will collectively preside over this hearing. We have many members of the media here today. I wanted to take a moment and express the Gaming Commission's sympathy to all of you on the recent and unexpected loss of your esteemed colleague, Lana Jones of WBZ News Radio. Lana will be fondly remembered for her kindness, her professionalism, and her extraordinary contributions. She's worked with many of us for a long, long time. We've left an open seat for her today in honor of her memory. The purpose of the hearing today is to determine whether Stephen A. Wynn remains a qualifier under Massachusetts law relative to Wynn Resorts Limited, Wynn Massachusetts LLC, and all affiliates. By way of background, as part of the initial casino licensing process, the Commission determined which individuals and entities would be required to participate in our background investigation to determine whether they were suitable to be associated with the casino. Those individuals and entities are referred to by us as qualifiers. Based on his association at the time with Wynn Resorts Limited and its Massachusetts affiliate, Mr. Wynn was designated as a qualifier as part of that process, which we referred to as our RFA-1 process. Given the change in circumstances, this hearing has been convened to determine whether Mr. Wynn remains a qualifier. Before I outline the process that this hearing will follow, I'd like to clarify the scope of this hearing. The hearing will be limited to the question of whether or not Mr. Wynn is still a qualifier. The hearing is not a forum for the Commission to consider Mr. Wynn's suitability, nor is it a vehicle to address the suitability of Wynn Resorts Limited, Wynn Mass LLC, or any other qualifier. As appropriate, those issues will be reviewed in separate proceedings. Nothing we have done or said prior to this time suggests any outcome or any predisposition to the outcome of those issues or those proceedings. With that in mind, this hearing will proceed as follows. First, we will ask our legal counsel to discuss the law that governs the matters before us. Next, counsel for Wynn Resorts will be offered an opportunity to present evidence as to why it believes Mr. Wynn is no longer a qualifier. They will be expected to address each of the topics raised in the hearing notice, including the specific issues outlined in Addendum A. This may be done via the submission of documentary evidence, witness testimony, or a combination of the two. Any commissioner may, of course, ask a question of counsel or of any witness at any time. At the conclusion of Wynn Resorts' presentation, we will similarly ask counsel for Mr. Wynn to present evidence on behalf of Mr. Wynn addressing the issues presented. At the conclusion of both presentations, we will offer an opportunity to present brief closing comments. At that point, the Commission will adjourn the proceedings and gather privately, as we have in all such other situations, with our legal counsel to deliberate over this matter and reach a conclusion. A written opinion reflecting the decision will be issued shortly thereafter. As a preliminary matter, we will mark 3 items as evidence in this hearing. First, the hearing notice which was sent to counsel for Wynn Resorts and Mr. Wynn will be marked as Exhibit 1. Next, the record will reflect that Wynn Resorts and Mr. Wynn each submitted a brief outlining their respective positions. We will mark the brief, including all attachments submitted by Wynn Resorts, as Exhibit 2, and the brief from Mr. Wynn as Exhibit 3. Do any of the commissioners have any opening remarks or questions? Thank you. Do either of the petitioners have any objections or other preliminary matters to address before we begin?
No objections.
Okay. And I now will have our stenographer swear in our guests.
Good morning. We'll just ask that any individual who plans on testifying at this hearing, please rise and raise your right hand.
I do.
With that, we'll invite our legal counsel to begin by presenting the law that governs the present matter.
Thank you, and good morning, Mr. Chairman and Commissioners. I'd like to provide an overview of the law governing the designation of qualifiers. The principles of such designation are probably fairly well understood, But to ensure a uniform understanding by all here today, I'll run through some of the key aspects of the law as it applies to this proceeding. The law governing the designation of qualifiers is drawn primarily from two sources. The first are the general laws, Chapter 23K, and we'll go through those momentarily. The second source of law is from the Commission's regulations, primarily Section 116.02. Both areas of the law essentially provide for the same requirements. So for clarity's sake here at this hearing today, I'll just run through the requirements in Chapter 23K. They apply to particularly three sections of Chapter 23K. It's Sections 4, 13, and 14, and we'll get into the specifics momentarily. As we know, the singular issue to be addressed by this proceeding is whether Steve Wynn meets the legal requirements to be designated as a qualifier. So I'll focus on those rules that apply specifically to the designation of an individual qualifier as opposed to an entity qualifier. Before I get to the specific classifications, I'd just like to note one important distinction that the law draws. And that essentially is that there are two classes of qualifiers. There are mandatory qualifiers and discretionary qualifiers. And as the name suggests, if someone falls into the category of a mandatory qualifier, the law says they must be designated by the Commission as a qualifier. If they fall into the category of a discretionary qualifier, the law, of course, allows the Commission to make the determination as to whether such designation is necessary to achieve the principles driving the gaming law or not. So with that, I'll note that in the memorandum that's been circulated already, we ran through all of the particular categories and classes of qualifiers, so I'm not going to read them here right now, but instead, I'll just identify the specific questions and inquiries that the law suggests that we ask as part of this proceeding. And we'll break it up, as discussed, into the two categories, mandatory and discretionary. The first, under the mandatory category, there are 6 inquiries that the law says we need to ask as they apply here. The first is whether Steve Wynn has a financial interest in the gaming establishment. And for purposes of clarity, the gaming establishment, when referred to, means the actual building, structure, and premises presently being constructed in Everett. As opposed to number 2, which is whether Steve Wynn has a financial interest in the business of Wynn Mass LLC. Wynn Mass LLC is, of course, the actual entity that was awarded a gaming license by this Commission. Number 3 is whether Steve Wynn is a close associate of Wynn Mass LLC. The term close associate is actually defined in the law in Section 2 of Chapter 23K, and the definition was laid out in the memorandum, and we can get into that a little bit later if need be. Number 4 is whether Steve Wynn is involved in the financing of the gaming establishment. Number 5, whether Steve Wynn can exercise control or provide direction to Wynn Mass LLC. And number 6, related to number 5, is whether Steve Wynn can exercise control or provide direction to a holding, intermediary, or subsidiary company of Wynn Mass LLC. In the present situation, Wynn Resorts Limited is the holding company for Wynn Mass LLC. Accordingly, this particular provision that I just mentioned, number 6, essentially covers all members of the board of directors and all officers of Wynn Resorts Limited. They would essentially be designated as qualifiers under the law, as they have the ability to exercise control or provide direction to the company. There are, of course, other ways individuals could fit into this 6th category. 2, for example, as a shareholder who owns over 5% of the stock of the company, as they too may be able to exert influence or control over the company. So there is certainly some discretion that's baked into this particular qualification as well. Those are the 6 mandatory categories of qualification. So if Steve Wynn falls into any one of those 6, the law says that the Commission shall designate him as a qualifier. In contrast, we have the discretionary qualifiers, and for purposes of these proceedings, there is only one inquiry that the statute says we shall make, And that's set out in Section 4, Paragraph 11 of Chapter 23K. And it says that the question is whether Steve Wynn has a business association of any kind with the gaming licensee. And unlike close associate, the term business association is not itself defined. But what we do know, though, is that the association should be of a quality in nature, such that one's designation as a qualifier will in some way advance the paramount policy objectives of the gaming law by ensuring the strict oversight of the gaming licensee. Since this is a discretionary category, the Commission need not designate everyone who has any business association with the casino, however small, as a qualifier. There are certainly other vehicles in the law that may be used to address these types of associations. So those are all of the applicable categories of qualifiers that are at play here today. This hearing, then, is intended to provide the Commission with the opportunity to gather the facts necessary to determine whether Steve Wynn presently falls into any one of those aforementioned categories. Some categories are by their nature more black and white than others. For example, the petitioners have submitted documents purporting to demonstrate that Mr. Wynn is no longer an officer or director of Wynn Resorts. If you accept those filings, you may find that on their face they establish those facts by substantial evidence. However, when it comes to determining whether there is an existing business association between Mr. Wynn and Wynn Resorts, there will likely not be any one piece of evidence that will carry the day. To that end, in the hearing notice that was served upon each of the petitioners and is included in the hearing packet here today, and will be marked, it's been marked as Exhibit 1, the Commission outlined a number of subject areas that the petitioners are expected to collectively address in their respective presentations. Evidence presented in response to these areas will help answer the business association, close associate, financial interest, and control and direction inquiries that I previously discussed. The list in the hearing notice, though, is not exclusive and it's not exhaustive, so further inquiry is certainly appropriate as necessary as part of this particular proceeding. In sum, a collective absence of evidence that Mr. Wynn falls into any of the aforementioned qualifier categories, or any direct evidence that he does not, would tend to demonstrate that he is not a qualifier. The opposite is also true, though. The presence of substantial evidence that Mr. Wynn does fall into any one of those categories would suggest that he is a qualifier. The significance of this review, of course, is that if an individual is deemed a qualifier, they must be found to be suitable. And with that, I'll conclude my comments and just note that certainly if any questions of law, whether substantive or procedural relative to this hearing arise, that General Counsel Blue and I are available here to answer any questions.
Thank you. I think it's off, Steve.
Thank you. I think we're ready to move to the other side.
Thank you and good morning. My name is Kim Sinatra, and I am the General Counsel of Wynn Resorts. Thank you for having us here today on our petition to remove Mr. Wynn as a qualifier from the license of Wynn, Massachusetts. I will have a very modest role here today, which is I'm here to answer any questions that you might have. Our affirmative presentation includes our new CEO, Matt Maddox, who will give an update on the actions taken since Mr. Wynn's resignation on February 6th that the company has taken in order to evidence his separation from the company. We will then go to Frank DiGiacomo, a partner at Duane Morris, and Jackie Crum, the General Counsel at Wynn Mass, who will address the regulatory and statutory issues that have been outlined in the hearing notice. We have submitted a brief and some documentary evidence. We will not go through that in detail, but to the extent that there are any questions with respect to those matters, we remain available for them. So I'm going to turn it over to Matt.
Thank you. Thank you. If we could pull the presentation up. I really appreciate the opportunity to speak here before the Commission. And as Kim pointed out, what I'd like to do is just walk through the last 60 days to just continue to evidence what the changes that we've been making and the things we've been doing as it relates to distancing ourselves and our company from our former chairman and CEO. As soon as this comes up, we'll get started. So, to kick it off, on February 7th, I became CEO of this company. It was a time of crisis, and people were completely unsettled. One of the first things that I decided to do was to hold town halls with all of our employees, 25,000 people, and remind them that this company is not about a man. It hasn't been about a man for 18 years. It's not, Steve Wynn is not a Wynn Resorts. Wynn Resorts is about 25,000 employees. It's about the people that grow this company every day. And we've launched an internal campaign and an external campaign called We Are Wynn that just signifies and tells the world, internally and externally, that what Wynn Resorts is a $20 billion company with 25,000 employees. And that's what it represents. On top of those town halls, talking to over 15,000 people in a 30-day period, trying to remind them that don't be worried. We are going to be strong. We are going to keep growing. Your job is safe. No one's going to buy us because right now people are nervous. You're safe. This is the best job in the business. On top of that, in a parallel process, we realized that we had to quickly distance ourselves from issues that had mired the company in litigation, founder-based issues that really would never allow our company to move forward. So on February 27th, I got our board of directors together and set a strategic priorities list 2 weeks after I became CEO. And I said, the first thing I want to do is get rid of the billions of dollars of litigation that existed between Universal Entertainment and Wynn Resorts, because that existed between two founders, not two companies. I called Universal Entertainment in Japan, asked them to meet me in a mutually inconvenient place. We met in Hawaii. In 2 days, we were able to settle a lawsuit where we thought it was worth $1.9 billion. They thought it was worth $6 billion to them. We settled for $2.4 billion, wiped away all claims, and are in full cooperation. Immediately thereafter, I realized that if you're going to settle something for $2.4 billion, we should equitize the balance sheet. Because as you know, we are always risk averse when it comes to debt. So reached out to probably one of the best known conglomerate integrated resort operators in the world, Galaxy Entertainment. They're headquartered in Hong Kong. They operate in Macau. They're a $40 billion company. And over a 30-day period, was able to work with Francis Loy and his team, and they ended up investing about 5.3 million shares in our company for $927 million, coming in as a passive shareholder and helped us effectively finance the Universal litigation, which continued to remove the mired past of founders fighting each other so we could move on. During that same period, Steve Wynn and Elaine Wynn agreed to drop a lawsuit between themselves about who had control over whose stock, who could sell, who couldn't sell, and a shareholder agreement that had locked both of them up disappeared. The first thing that I did was call Steve Wynn. I didn't talk to him about business during this period after he resigned, but I called him and I said, your 12 million shares need to go in strong hands for this company. We can't have it dumped into the market, into hedge funds, and create more chaos. Out of the 12 million shares, he sold 4 million shares immediately through J.P. Morgan and Jeffries into those exact hands, the market, the hedge funds, et cetera. It was a really contentious day. I immediately went out and found Capital Research. They manage over $1 trillion. They're one of the biggest investors in the world. And T. Rowe Price, probably the largest investor in gaming. Worked carefully with them, and they agreed to take the remaining 8 million shares of Steve Wynn's holdings, or $1.4 billion, so that the company could have strong shareholdings. So we were able to place, in the last 60 days, 13% of our company in Galaxy Entertainment, T. Rowe Price, and Capital, which is solidifying the shareholder base that's going to help make decisions in the future. So on top of that, I've been really proud of what our board's been able to do. If you look at the last 60 days, and then you go back and you think about and look at all companies that have gone through board refreshment. In 60 days, we've had 4 board members resign or say they're not running. And we've refreshed our board with 3 new diverse female directors. GE, as you know, who's headquartered here, has gone through a massive board refreshment. It's been almost a year that they've been working on it, going from 18 to 12, replacing people. In 60 days, we've had 40% change. And our board has said we're not finished. We're still on the way. So while it may feel like things aren't moving fast, they're moving at lightning speed. The changes we're making to distance ourselves from our former chairman and CEO and to focus on the future. If you think about the people that we brought on, just I'd like to make these points. Betsy Atkins, if you were to look her up, she has been on over 20 public company boards. She's known as a corporate governance guru. She's turned around multiple companies from a board of directors in terms of corporate governance, and she was excited to take the role. Dee Dee Myers is one of the best people in crisis communications, strategic communications, and she is the one of the right hands for Keith at Warner Brothers in dealing with sexual harassment and dealing with gender issues at Warner Brothers in Hollywood. She's leading this effort. She wrote Why Women Should Lead the World. She's one of the smartest people that I've met. I talk to her a lot, and I'm really excited that she's on our board. And in fact, there was a little bit of controversy about should Dee Dee come on the board, because Dee Dee didn't have any public company board experience. And all public companies almost make that a requirement. And I made the impassioned speech to our board. That's exactly why there aren't women on boards. That's exactly why. Because if you have that requirement, you have a limited pool. So why don't we lead in this effort? Why don't we pick someone that's really smart, that's going to be great for our company, and is breaking the mold? And our board had the courage to do it. We also brought on Wendy Webb. She's a 20-year veteran at Disney, a finance expert, ran all shareholder services for Disney during that time, was in the C-suite at Ticketmaster. All 3 of these people have joined our board, and we are now in the top 40 of the S&P 500 in terms of female representation on our board of directors. And it's something that I'm very proud of and something we've been able to accomplish
Mr.
over
Maddox,
the last 60 days.
just comment on that, please.
Yes,
Obviously, these women are eminently qualified,
yes,
and you've been at a high level of that company for a number of years.
Yes.
They were eminently qualified 2 years ago, 5 years ago.
yes.
I just can't, I just have to make the point that there's an issue around women, and now women are more valuable to the board. I see what you're doing, but it just seems to me that the company as a whole didn't value women until they got in trouble at the board level. Anyway.
Commissioner Cameron, maybe it's because there's new leadership. I'm a 42-year-old man. I have a 12-year-old daughter. I have a 10-year-old daughter, and I have a 10-year-old son. And if you think for 1 second that I want my 10-year-old son to have any additional benefits or have a better environment in the workplace than my 12-year-old daughter and 10-year-old daughter, that's not true. I am part of the generation that believes this. I'm part of the generation that's driving this. And so I don't think it's anything about what the company did do or didn't do. I think crisis sometimes creates opportunity. You can either let crisis drive you down, or you can take it and you can make something great out of it. And that's what we're doing. It's what I'm committed to do. Also, not just the strategic moves that we've made in terms of financial distancing ourselves from Mr. Wynn, we've also launched a full cultural and diversity department led by Corinne Clement. And she is known as one of the top leadership development people in the country. She has a full staff. We've already rolled out leadership development programs. We have a women's leadership forum that's going to be hosted next month. We've rolled out our Wynn Resorts Back of House campaign. And here's what I believe. The only way to really understand what's going on is you have to set benchmarks. Starting Monday, the Fortune 100 greatest companies to work for are coming in and surveying every one of our people on a confidential basis. Confidential. They don't have to put their employee number in. Every one of our people. And they're going to answer 60 questions. And a lot of them relate to the issues that we're talking about today. And then we've also brought in...
Say that they're all 25,000 employees? What?
No, all 12,000 employees. Oh. We're launching it in North America only.
Okay.
So the 13,000 people in Macau, it doesn't translate cross-culturally. They have a different process that they're going through, but we're doing it there too. We've also brought in Mercer, who is the best in gender pay equality. They are launching a full study on those. And we're going to take those results, whatever they are, and we're going to be transparent about them, and we're going to improve on them. It's the only way you improve. So the things that we've done over the last 60 days, I think, are showing how quickly we are moving into the future and how we're continuing to think about we're going to lead this industry. I'm committed to lead this industry on these types of issues, not just on service, not just on great product, not just being 5-star. We're going to lead in gender equality. We're going to lead in diversity. It's something that I am committed to, and we have already reprogrammed all of our sexual harassment training. We realized actually that having employees provide sexual harassment training, it's actually a little bit uncomfortable for people, and so we're bringing in a third party, a couple third parties, to review how you do it, to make it very formal and to work through everything. So while I think we were doing industry standard before, we're going to leapfrog the industry in these issues because it's important, and we are going to have this done in the next 90 days.
Mr. Maddox, I assume the training will include the fact that it should apply to everyone in the company.
Absolutely, top down.
And because the policy's only as good as the implementation.
Starts with me, right at the top. These are things I'm leading on. I have an employee communication. April 6th, I wrote a letter to all employees. It's posted all over the back of the house with the "We Are Wynn" signs that talks about this, that talks about how it is and how important it is to me, and how we are taking this seriously. These aren't issues that you're defensive about. These are issues that you look at and you say, we can be better, and we're going to be better. We're not defensive. Do I think we were fine in the past? That's not the point. How can we be better? We are doing things right now to lead this industry. So one quick thing I'd like to do is if we could just put a video up. The reason this is important is I don't want people to think Wynn, the name, is associated with a man. Yes, it's a man's last name, but it is a brand that customers come to respect. In fact, we polled hundreds and hundreds and hundreds of customers checking into our hotel, into Wynn. 60% of them that we polled had never heard of Steve Wynn or any allegations. 60% of the people checking into Wynn. 40% of the people had heard of him and had heard of allegations. And of that, 90% of the 40%, or let's say 36% of those, said, we love the property, we love the service, we love the food, they all had things they love. We actually don't care who's running it. That doesn't mean anything to us. 4% out of all out of everybody that we polled said what we've read about could influence our decisions in the future. So I'm only giving you that as context, that the reason that we are continuing to talk about our brand is because two things. One, 75% of our profit comes from China, and 95% of our customers over there have never heard of Steve Wynn. He only went there one time last year for 2 days. His picture's nowhere. He's not on any TVs. He's not on any hold music. We didn't embrace a cult of personality in China because it was the wrong thing to do, like we did in the United States. And what we're doing now is redefining our values and our behaviors and what Wynn stands for. And that's what we're going through that process in detail, and we're going to instill those values in the brand. And so if we could just play this video quickly, and I only have a couple more minutes.
So much more can be done as a team versus just as an individual.
We all come together to create this experience. People here really care about the community and this place. I don't look at it as, oh, I have to go to work. It's like, okay, I'm going to go see my little family.
The care for one another, the level of professionalism.
It's just a rare breed of people. I'm very proud to be part of it.
I was hired on April 7th, 2005. Wynn in my life is who I am. When I smile, I do it because we are very blessed.
I'm one of the ones that escaped from Cuba in 1993. I'm one of the rafters, huh? 20 years old. I just thought that I have 99% a chance to die, but a 1 chance to be alive. And that's the chance I took. I came here to work hard, and I'm very thankful to work for the Wynn and be what I am right now.
The soul of the company is one of community. Everyone is needed and everyone is valued. When I see the name, that's home. I am the Wynn. I am a Wynn employee.
I am a Wynn employee.
I am a Wynn employee.
I'm a Wynn employee.
I am a Wynn employee.
But together.
We are Wynn Resorts.
We
are Wynn Resorts.
All right, you got it.
Perfect.
The point of that is the culture of the company. And that's what I'm instilling every day is the 25,000 people are Wynn Resorts. If you think about what it is that we stand for and what it is that these 25,000 people do, what we stand for are the opportunity for people maybe without college educations, for 25,000 people that aren't high skilled to make $75,000 or $100,000 a year and live the American dream. You get to buy a house. You get to put your kids through college. There are very few businesses left in this country that do what we do. And the reason we do it better than everybody else is the reason that we're at the top. We have the best customers. It's really simple. They tip the most, which means our people make the most money. And they get a better life. That's what we're here to do. That's what we're about, and we're about change. Thinking about what we're doing in Everett right now, $2.5 billion that we're investing. We have we've hauled off 840,000 tons of dirty dirt, enough to fill Fenway Park. We've cleaned a site up. We have 1,600 people working on the site every day, 1,500 to 1,600 construction workers working on the site every day. We're going to be employing 3,500 to 4,000 people and making a better life in a hollowed out middle class, which is existing throughout the country. We're very focused on doing the right thing. That's what this company's about. And as CEO, I can tell you there is no association with Steve Wynn. There is no business association with Steve Wynn. I'm my own man. Kim Sinatra is her own woman. We are moving this company forward. We're excited to move it forward. We're excited to think about the future, but we're taking these issues very seriously. We're not defensive. We're on offense. So what I'd like to end with is the Wynn brand is strong, and I understand it, and I believe in it globally. I also understand the cultural sensitivity here, and we've heard it loud and clear from the beginning. And so we will use, if the commission is okay with it, we would like to propose that we change our name to Encore Boston Harbor. We're ready to change the wrap on the construction fencing today. It's already been prepared. We're ready to pass out T-shirts, Encore Boston Harbor, to all 1,600 construction workers. By the way, it's interesting that we decided to pick this day. Today's the topping off of Encore Boston Harbor. We're hosting all 1,600 construction workers. I'll be speaking to them. After this meeting, we're giving them all lunch on the casino floor to celebrate the topping off of the largest private investment in Massachusetts. It's really exciting. So what I want you all to know is that we're listening, we're paying attention, and we are cooperating as best we can with your staff, and we're excited about the future. With that, I think I'll turn it over to Frank DiGiacomo.
Actually, I may have a clarifying question, Mr.
Sure.
Maddox. You mentioned that survey that you conducted where 40% of your clients, it was a 60-40, 40% had not heard of the
60
allegations.
either had not heard of any allegations.
Right.
40% had.
Was that North American clients? Are you including your Macau clients?
No.
How does that break down?
That was an internal survey. We hired an outside group to stand in our front desk and ask people questions. So it was people actually checking in to Wynn. We've actually gone out in the field with Heart and Mind. It's an extensive survey in all of our key markets. They're in the field right now asking all of these questions to thousands and thousands of people in key markets. The first survey I was referencing were actually people checking into the hotel.
But only in North America.
Yeah, only in Wynn Las Vegas. Only at Wynn Las Vegas. Yep.
You also, in the materials that included in the presentation, there's a note that says the company has separated the chairman and the CEO roles.
Yes.
You are the CEO currently.
I'm the CEO.
Is that chairman position filled, or is it vacant, or
It's
who's-
filled. A
who's-
gentleman named Boone Wason was named chairman.
Boone Wason.
Yes.
And he's prior
Prior board member.
prior board member?
Yes, yes. I believe the board thought it was important, since we are a gaming company, to have a chairman of the board that was a gaming executive during this refresh process.
Right.
So that's, I believe, why Boone Wason was chosen.
Okay. There's also, in your presentation, you mentioned there's the passive investment of Galaxy Entertainment.
Yes.
As well as 8 million shares or so between T. Rowe Price and Capital Research.
Yes.
Are those also passive investments?
They are.
Are they envisioned to get any further than the 5% under which they are, to your knowledge?
Well, Capital Research and T. Rowe Price are institutional investors.
Right.
There are no standstills or lockup agreements or shareholder agreements with any of those investors. They could sell tomorrow. I just reached out to Capital and T. Rowe because they're the largest investors in gaming.
Mm-hmm.
So I'm not sure what their intentions are, but I can tell you that Galaxy has said publicly that they do not have intentions to go above the 4.9%.
Right.
Go ahead.
Two quick questions.
Sure.
One related to the board. You talked about you had 4 board members who were either planning on leaving or were not running for re-election to the board. You've introduced us to the 3 new board candidates. Can you tell me how many board spots you have left, kind of to the degree you can tell us about your future plans to fill those remaining board seats?
The board of directors is going through a refresh right now, so I don't actually have an answer for how many more candidates we will fill or how many will come down. I do expect that this summer there will be additional candidates named to the board. I'm not sure, but I don't know about any additional people stepping down. I'm not privy to those conversations.
I
But
might be
do know
able to
that-
help you on numbers. So the bylaws provide we have to have between 7 and 13 board members. The board has flexed in size over time, depending on retirements, additions. And so there isn't a static number. I do know that there will be additional changes to the board and that this was just the first step. And I think that the idea is to make it an orderly transition. This is about as much as a public company can take at one SWAT, which is a 30% turnover.
So how many board members, I'm sorry, how many do you have currently with the recent additions?
I think this gets us to 11.
Yes.
Okay.
One other quick question. You pointed out a number of the kind of meaningful steps you're taking to solidify and promote cultural improvement. To the degree you can say, a number of these initiatives, I would suggest, don't happen overnight.
Mm-hmm.
How many of these initiatives, have been on the back burner, have been discussed previously with the company? How many of them are kind of new rollouts? I mean, are a lot of these things just coming to the forefront since February?
No, that's interesting. In 2013, I was named president with the idea that I would be the eventual CEO. And the concept that the board laid out was when Steve Wynn would retire from CEO in 2020, when his term was up, but probably still remain on the board. All of these events accelerated my succession to the CEO role. Mm-hmm. But when you are in that role, you keep a list of things that you would do differently, because you have to be your own leader when you step in. So it wasn't that, oh, what do we do? Right when I became the CEO, we pulled the management team together, and they were familiar with the list, and we said, let's get going. Here are things that we've been wanting to do in the past. Here are things that we have talked about extensively. Now it's time to make these things happen.
Thank
you. Sure.
Mr. Maddox, what is the organization that's doing this big 12,000-person survey?
Fortune.
It's called, the company's called Fortune?
Yeah, Fortune magazine.
Oh, the magazine, okay.
They put out, it's probably the most popular survey nationwide. You've seen it branded, I'm sure. 100 greatest places to work.
Oh, yes, right.
So
I didn't know they interview all 12,000.
Well, all 12,000 people have the opportunity. They come in, it's online, it's 60 questions. We added 15, which are all sort of related to the issues that we're talking about today. And, but there's 60 standard questions. And then we encourage as many employees as possible to take that survey. It doesn't mean everybody is forced, it's not mandatory, but I expect really high turnout.
Will we be able to see the unexpurgated results of that?
Sure.
That'd be interesting.
Sure.
Anybody else?
Mr. Chair, may I ask one question?
Sure.
Mr. Maddox, you've talked about, and I think I saw you on Squawk Box earlier this week, that you have had some contact with Mr. Wynn since his separation from the company. Is that correct?
Yes.
Could you just describe to the commission, since his separation, the approximate number of times, the nature of the contact, and when the last contact was?
There was significant contact between the day he resigned and the day we signed his severance agreement, because we had to really work through his entire life that was built into the company, what was his and what was the company's. So significant communication as to fair value of couches, chairs, can't go on the plane. So lots from the 6th to the 15th. From the 15th to when we settled Universal, very little, because I don't know if he ever called. Oh yeah, I did put this in. And then after the shareholder agreement went away, I had lots of communication with him, numerous calls about getting those 8 million shares in strong hands. The last time that I spoke, we don't talk about business. The last time, let me be clear, he's asked me, how's business, of course, probably 2 or 3 times, and I've given the same answer that I give to anyone under Regulation FD. The last time I talked to him was just a couple of days ago, because I called him and I said, are you going to not vote your shares in this upcoming proxy election as your 13D indicated? Because we have a proxy election right now with directors, and he was actually a shareholder of record when that happened for 12 million shares. So I called directly, because we're trying to understand who's voting for who. I called him directly to ask that question. And he indicated to me that he will follow what he put in his 13D, which he would not be voting the shares.
Thank you.
Mr. Maddox, you talked about having a list of stuff that you would like to do when you took over, apropos of the question of some of the diversity initiatives and so forth, and that Commissioner Stebbins asked you about. It's implicit in that that you felt there were some issues that needed to be addressed when you took over. Am I right in perceiving that?
No, when I was referring to the list, it really had to do with the transactions that we made. So the universal litigation, the $2.4 billion, equitizing the balance sheet with some people that are operating in Macau, settling the ongoing feud with Elaine Wynn. 6 years of litigation with Elaine Wynn was tiresome and distracting. So those were the things that I had on my list. I also had on my list leadership development programs, and we've been talking a lot about diversity and inclusion and how to roll those things out in an effective way. So those were not suppressed in any way, but it's something that we had talked about a lot. How do we do this? And this really gave us an opportunity to use it as a springboard and to realize we probably should, now is the time, and we can make this happen.
Anybody else?
Mr. Maddox, you have given us information about the importance, you understand the importance of separating from Mr. Wynn at this point. Contacts, they're all non-business. Would you say the board also shares that understanding that that is an issue that we have to pay attention to when it comes to control? Those contacts with Mr. Wynn, do they understand that as well, particularly the board members who are longstanding?
Absolutely. Absolutely. I think you will see, I haven't seen, but I'm assuming you have seen their communication with Mr. Wynn, and they absolutely understand this. We know for sure this investigation needs to be thorough, pristine, and transparent. We're committed to it, and the board's committed to it.
You're talking about your own investigation.
That's right. We're committed to it. The board's committed to it. It's the only thing that you can do in these situations. And so, yes, the answer is yes.
Thank you.
And from a proof perspective, we did submit an affidavit outlining all of those contacts. Many of them are none. We also have put in place a process by which any senior officer or director who has contact, direct or indirect, with Mr. Wynn, reports that contact to us. So I think that everybody understands exactly where we are on that topic.
And Commissioner will get into that further as the hearing proceeds.
This actually jumps ahead to Mr. DiGiacomo's submission, but you did write, additionally, Mr. Wynn no longer communicates with or otherwise remains in contact with any officer or director of Wynn Resorts. That sounds like it's not quite the case, and it frankly seemed to me to be pushing the envelope. Nobody's asking that there not be any contact whatsoever, even with old friends, but that's what you wrote.
That statement was a looking forward statement and with respect to business association terms, but understanding the chairman's comment, we'll address that.
I mean, because in your testimony, you're going to address it?
Yes.
All right, fine, okay.
Yeah, there are communications, and Jackie Crum will go through those with some specificity, and we'll present the evidence, and then should the commissioners have any questions with respect to those various communications, we're prepared to answer those.
Okay. Anybody else? All right, next up,
Mr. Chairman, Commissioners, Frank DiGiacomo, good morning.
Good morning.
Just an evidentiary matter first. We would like to have the PowerPoint that Mr. Maddox referred to, and along with the video, I think marked as Exhibit 4. Is that the next? Thank you. As already been stated several times here today and by Mr. Grossman, the purpose of today's meeting is to consider the legal question. The legal question is to Mr. Wynn's status as a qualifier in connection with the Category 1 license held by Wynn Mass. Chapter 23K in the Commission's regulations set forth the criteria that determine whether or not an individual is a qualifier. If an individual no longer meets those criteria, that individual, quite frankly, is no longer a qualifier. And through the evidence submitted by way of exhibits through our brief and through testimony today, it's our position it'll be clear that Mr. Wynn's status should no longer be that of a qualifier. In connection with the hearing notice received, that notice requested that Wynn Resorts and Wynn Mass have a person designated who will testify on behalf of the companies with respect to the items set forth in Addendum A. And that person is seated to my right. That's Jackie Crum. She's the Senior Vice President and General Counsel of Wynn Mass. And we also submitted an affidavit of Ms. Crum, and I would move that we mark that as Exhibit 5.
I don't think we've seen that, right?
Yeah, we saw it.
Yeah. Oh, we did? Mm-hmm. Oh, last night?
Yeah, the purpose of the affidavit addressed the specific items set forth in the hearing notice, the April 19th hearing notice, particularly those items set forth on Addendum A. There were 12 areas of inquiry upon which the representative of the company should be prepared to testify to. And following receipt of the hearing notice, including the addendum, Ms. Sinatra reached out to the various board members, contacted the board members and officers of Wynn Resorts and Wynn Mass, provided a copy of that hearing notice, and as a result of that, those individuals responded to Ms. Sinatra, and the responses are detailed with some specificity on the affidavit, but Ms. Crum certainly prepared to expand upon those should the commission have any specific questions with regard to those. So the affidavit sets forth the various inquiries by number and then provides a general responses from those directors and the specific officers who responded. And with respect to the qualifier status of Mr. Wynn, and at risk of being somewhat repetitive, as set forth in the exhibits and the SEC filings, Mr. Wynn clearly no longer an officer, no longer an employee, and more significantly, no longer a shareholder of Wynn Resorts. So the mandatory qualifier status with respect to those positions is not in doubt and supported by SEC filings, supported by the submission made by Mr. Wynn through his counsel as well. There is a set forth in this PowerPoint the various categories, and I'll point to the one that defines the term close associate. A close associate is an individual defined who holds a financial interest, whether direct or indirect, in the licensee. As a result of his divestiture of his shares, Mr. Wynn no longer holds such an interest. More specific, the close associate designation also encompasses a person who is entitled to exercise power over the business of Wynn, Massachusetts. Mr. Wynn no longer has that power as a result of his resignation from his positions and the divestiture of his shares. He's not able to influence any significant influence over the management of the operation. As Mr. Maddox alluded to, he's making those decisions as chief executive, delegating to those individuals who have responsibility to the specific property. So Mr. Wynn clearly no longer has a financial interest, no longer can exercise control. He's just a member of the public, not a shareholder, not an executive in any regard. Now, as part of the separation, there are two significant agreements that were attached to our brief, and that the first is the separation agreement that was entered into by Mr. Wynn and the company on February 15th, and that agreement sets forth the specific terms of the separation. So this agreement in itself is a tool, a mechanism, a contract by which this separation is being effectuated. There are, he resigned immediately from the board. He received no additional financial benefit. There are sections in there regarding his vacating of the villa at the Wynn Las Vegas property, continuation of health care benefits and administrative support for some brief period of time. But this agreement is part of the separation of Mr. Wynn from the company. There's also the surname rights agreement, which is also referred to in the separation agreement, and we're prepared to answer any questions with respect to that. So turning to the business association term, I get again, these agreements are really the only agreements between Mr. Wynn and the company that currently exist. And the purpose of those agreements and the effect of those agreements is to disassociate Mr. Wynn from Wynn Resorts and Wynn Mass.
Mr. Giacomo, what do you collectively call these agreements? The separation agreement is one of them.
Yes.
Any others?
There's the surname agreement, and that's a agreement.
Yes. Surname rights agreement.
Yeah, the surname rights agreement, which was referred to in the separation agreement, was entered into in August of 2004.
Is that surname rights agreement still in effect?
It is in effect. It is a perpetual term, and there's no payment for it under that agreement.
So the company has the right to use the Wynn name, last name, and logo, if I remember correctly the terminology.
Yes.
Right.
That has been settled, he's been remunerated in whatever case in the past.
Right, so under that initial agreement, it said that, you know, the consideration has already been received.
Has been received.
Yeah.
But there's, you have the option to discontinue that. Is that not correct?
That's correct. And the change in the severance agreement was that to the extent that the company elects to cease using the Wynn name in any way, Mr. Wynn has the right to reclaim it.
Right. But until you decided that,
We have the
You
right.
cannot
It's a
claim it.
royalty-free right.
Right.
We actually got it on the cheap. I don't think he ever got paid.
when was that, in 2004?
In 2004.
Yep.
Again, these agreements are part of the process of disassociating from Mr. Wayne. This slide, and I wanted to show the effect of the qualifier status and really to demonstrate how it serves no regulatory purpose at this point, given Mr. Wynn's status, to deem him a qualifier. So really, if the commission were to continue to require Mr. Wynn to qualify, three things could happen. First, he would submit the qualification and be found suitable. That could occur. Mr. Wynn could submit the qualification and be found unsuitable. Or he could refuse to submit the qualification and ultimately found unsuitable based on his failure to cooperate or refusal to cooperate with the investigation. Under 2 and 3, the result of a disqualification in the gaming world is, at that point, a disassociation from the unsuitable person. That disassociation has already occurred here. This commission, even in some of the earlier rulings with respect to the Suffolk Downs application, for example, allowed for a divestiture trust for one of the shareholders, Renato. And the purpose of that trust was to put in place, and you approved an orderly process by which that applicant at the time could disassociate from an uncooperative qualifier. So in that situation, this commission approved a trust to ultimately, that set forth the terms of a divestiture should that licensee have been selected. That is consistent with what other gaming regulatory agencies have done in the unsuitability context. New Jersey had a series of cases when they came on board early. In those cases, when shareholders, insignificant shareholders, were found unsuitable, the regulators allowed for the disassociation of that unsuitability, of that unsuitable person, and made that a condition of licensure. The disassociation was a termination of any existing employment relationship and a divestiture or a redemption of their shares. That has already occurred here. So if this board were to deem Mr. Wynn a qualifier, he has already disassociated. He could not disassociate twice. It's an impractical result. And I think that supports the specific arguments that Mr. Wynn does not meet the legal definition of qualifier. With respect to, turning back to I guess now Exhibit 5, Jackie Crumb's affidavit, I want to walk through the process by which we made inquiry into the specific items in the hearing notice. And I don't know if Jackie, if you just want to address those.
So on April 19th, Kim Sinatra sent out an email to the Board of Directors and officers of the company asking them to respond to the addendum A that was part of our notice. She copied Frank DiGiacomo and myself on that email and asked them to respond to all of us. As a result of those responses that were received and additional responses and follow-up questions, we were able to compile my affidavit accordingly.
I don't know if the commission has specific questions.
Did you speak directly to the people you referenced in the affidavit?
I spoke to some of them directly with follow-up questions. Most of them answered the questions in email format, so I used those emails to compile the affidavit, and if I had follow-up questions, I did reach out to them.
You're saying that even people who have been longtime friends, in some cases practically since boyhood, have decided and are promising not to have any relationships, even casual, not to bump into each other at their summer house or.
I wouldn't go that far that they're not going to ever bump into each other. What they have said that they will do is if they do have any communication, they will report it, and we will be able to report that into the commission. They also have committed to not have any business communication. So if it is social, that's what it would be.
Right, okay. But the statement does, the statement in the document is a little more explicit than that. It does say, no longer communicates with or otherwise remains in contact with any officer or director. And, you know, that's on
actually
page.
in the brief.
That was in the, yeah, that was the brief, and that was a bit of advocacy. And again, that was from that date of that brief moving forward.
No, but I mean going forward. I mean, it's fine, but you're just representing that in that statement that there will be no communication.
To the extent that was not meant to be. So that interpretation or that position was not meant to be put forth, if that's how you're interpreting it.
Okay.
I think
I mean, I wouldn't want I wouldn't want, you know, that kind of a communication to be a breach of what you have put to us under oath.
I think the purpose of that communication was to demonstrate that there will be no further business communications with Mr. Wynn at any time.
Okay.
I think it's also should be pointed out that a single director, even if Mr. Wynn had communication with that director then could not, on their own accord, significantly influence a decision by Wynn Resorts. That's done at the executive level. So you know, those types of casual conversations, my term, personal in nature, the reference in the brief was to be specific to business type communications.
I think from my standpoint, I mean, the boxes that are the formal boxes seem to me to be clearly have been checked and checked expeditiously. You know, the close associate, you know, the law defines what that is, and the word entitled is in the word close associate, so it doesn't mean just a friend. It means somebody who is entitled to exercise power. And I think you've suggested that's a pretty slim, if not next to impossible. It's not entitled in any way because of some business relationship. There is the practical reality. If there were, for example, an effort to remove a board member who is a longtime associate, it would be very tempting, I would think, for him to want to lobby whoever on behalf of his longtime friend, the board member. And that's maybe a little bit outside close associate or effect, but it's within your commitment that there won't be any business communications, and I think that's something that we want to be able to rely on. But you know, these are human beings. Human beings are involved here. There are multi-year relationships involved here, and I don't want us to kid ourselves about the possibility of some kind of non-trivial, powerful influence by a very compelling, powerful personality on such things.
Mr. Chair, may I ask a follow-up question on that? Attorney Crum, in your filings, you described a process that the company is going through internally for a notification process for communications. Can you describe that, please?
Sure. So as one of the things, and I will tell you that the communications that the Board of Directors communicated to me, it was a discussion, for instance, on a book on tape that Mr. Wynn had been listening to on China. They were casual, social conversations. A number of the board members reached out to thank him for resigning and tell him that they thought he'd done the right thing for the company. On a going forward basis, we've asked all the officers and directors to please notify us as soon as they receive any communication from Mr. Wynn and what the subject matter of that communication is, so that we can say whether it's personal in nature or whether it does cross the line or enter into a gray area. And we would be prepared to share those communications with the Gaming Commission.
So that is something that you could do and within 24 hours let our Investigations and Enforcement Bureau know?
Can I not commit to 24 hours, as people do sleep and live in different time zones, but I will do it as promptly as possible. And
We could probably figure out a appropriate time frame.
Thank you.
We've asked the directors to report to Jackie within 48 hours of receiving any such communication, so we can certainly work with staff with respect to a specific turnaround on those.
Just as a quick follow-up on that point, Ms. Crum, in your affidavit, you talked to making those notifications by officers and directors available to the commission upon request. I'd strike the upon request.
I assume the request is ongoing, so.
Yes. Yeah. Thank you.
It was my question, whether they've been asked to or directed to.
We have asked them to do that at this point, and we will follow up with a more formal direction that is the policy.
One other question on this affidavit, Ms. Crum, you talk about inquiry number 11, which is in the middle of page 5. You say the only debt obligation owed to Mr. Wynn by Wynn Resorts relates to his city ledger account.
Actually, that's not a debt owed by Wynn Resorts to Mr. Wynn. Sorry, it's not a debt owed by Mr. Wynn to Wynn Resorts. It's he put up money as part of his city ledger, so that's the balance that's left, and that would be a debt that essentially would be repaid to Mr. Wynn. And Matt, I'm not sure if that's been done or whether it's in progress.
So many of our directors have money on account. Under Sarbanes, we never wanted to be in a position where either officers or directors owed money to the company. So to the extent that they eat in the restaurants or had retail or any other services from the hotel, they were covered by a balance that was kept at the hotel. We're in the process of winding down all of the relationship with Mr. Wynn, and so when that's concluded, we'll return his money.
And just to give you some additional information, on March 31st, 2018, the balance was $230,769.42. So that obviously will be returned to him to the extent that it's still there.
Can I follow up a little bit on those unwinding of financial relationships? Mr. Wynn had a substantial amount of art that he owned or lent to the for use to the company. How is that? What can you give us a little update on that situation?
By the end, there wasn't that much overlap, but there were a few pieces that he owned that we had on display in various places. We've settled that out. He took his art back, and we kept a few pieces that are vases in one of the restaurants, but we've settled out any ongoing relationship with respect to the art.
Mm-hmm.
Yes.
What happened to Popeye?
Popeye's still waiting.
Who owns, so Wynn Resorts owns Popeye?
Yes.
Okay.
And there's a few boxes in storage, but that is the extent. When we went through the inquiry with all the officers and directors, that was the extent of property that's still owned by Mr. Wynn that's on property.
Yeah, we'd love to see Popeye over there on the Mystic River, for sure.
And to state the obvious, Mr. Wynn is no longer on the property.
That's correct. He's vacated his villa.
Other questions for Wynn Resorts?
I have a hypothetical, if you don't mind. Is it fair to say that had you not settled the lawsuits that you did with Universal and Elaine Wynn, the relationship with Mr. Wynn would have been one of that either puts you at odds or in the same interest, depending on those lawsuits? In other words, he might have been exerting indirect influence if those lawsuits were still ongoing. Is that a fair statement?
I think if we wouldn't have settled all of those issues with all of those three different former and current shareholders, then you're right, it would have been hard to move the stock on. So yeah, it would have been, I think you're right, it would have been more complicated. And that's why on February 27th I said, we have to reduce the complication and we have to solve all this litigation, not just for Mr. Wynn or the company, but for Universal and for Elaine and this fight that had been going on for 6 years. Not worth it. So that was step one, to just clear the decks.
So that leaves now Ms. Elaine Wynn as the largest shareholder,
She is.
but she's not currently a board member?
She's not.
And you mentioned an annual meeting coming up?
Yes.
Will there be board nominations at that time, or board?
No, that was the 3 members that we appointed last week were in our proxy as the new board members that will be coming up.
I'm sorry, one just last quick question for Attorney DiGiacomo. And you might have said it, and I apologize if I missed it. Do you have a definition of what business association means?
Well, certainly, certainly our position that neither the separation agreement nor the surname agreement are a business association, the type of which that regulation was meant to address. It's not of the nature or the extent that would prompt a regulator to want to regulate the individual that has that type of association. First off, it's part of this association, particularly the separation agreement for Mr. White. And the surname agreement, since he receives no financial remuneration and it was entered into in 2004, we would submit that it's not a type of business association that requires him to be a qualifier under the regs.
Thank you.
Is that it for Wynn Resorts? All right, thank you very much.
Thank you.
And we will
Thank you.
ask the representative, anyone want to take a break, or are you all right?
Yeah.
Let's take a quick break while the groups change. Before we do break, we do have a tradition at the Gaming Commission of introducing distinguished public officials who are here, and I just noticed that Mayor Carlo Di Maria is visiting us. Welcome, Mayor. Nice to have you here. Thank you. We'll take a 5-minute
Mr.
break.
Chairman, one evidentiary matter, just to move the second PowerPoint into evidence.
Exhibit 6.
Thank you.
Okay, thank you. We'll be back in 5 minutes. We are reconvening our public hearing on the Steve Wynn application relative to his qualifier status. I apologize, we've had some technical difficulties. Our internet feed of our live stream is compromised. It's available in some places, not in others, but we will go ahead. It will be recorded and will be posted as soon as we get the recording back. I think we now are to the next item on our agenda, which is representation of Mr. Wynn.
Yes, good morning, Brian Kelly, Joshua Shaw.
Green button.
That'll help. Good morning, Brian Kelly and Joshua Sharp of Nixon Peavy for Mr. Wynn. We appreciate you inviting us here today. I think, and I don't disagree with a lot of the legal analysis and the factual statements made by the Commission's counsel and the company's counsel. I would note that with respect to the evidence that we've offered, we have in fact attached numerous documents to our brief, which are now in the record, and that would be our evidentiary record. I do think, at the risk of having everyone's eyes glaze over, I would like to address the law very quickly and succinctly with respect to whether or not Mr. Wynn is a qualifier, because that's why we're here. And it's our clear and unequivocal position that at this stage, under the existing law and under the relevant facts, he's not a qualifier and he's no longer relevant to any ongoing proceedings here. So as I have viewed the law and the analysis, and I think we're consistent with the Commission's counsel, there's really 6 different possible ways you could conclude somebody is or is not a qualifier. And I think the first 4 can be wrapped up pretty quickly and can be given a fairly quick analysis. And the first 4 arise out of Chapter 23K, Section 14's A and E. And those are the 4 provisions which talk about a qualifier can be any person with a financial interest in a gaming establishment, any person with a financial interest in the business of a gaming licensee. Number 3, any person participating in the financing of a gaming establishment. And number 4, any close associate of a gaming licensee. Now, in light of the fact that he has sold all his stock, he's stepped down from a position of authority, I think those first 3 prongs are pretty clearly no longer applicable. He's not a qualifier under that. If you go to that 4th prong, that is he a close associate of a gaming licensee. He's not. That's a term, a phrase, a close associate. This just doesn't mean anything you want it to mean. It's not like he's friends with this person, or he's friends with that person. He's got a lot of close associates in Las Vegas. He's got a lot of friends. He's lived there a long time, and that's not what it means. The phrase close associate is defined by the statute itself, and that would be in Section 2 of Chapter 23K. And the close associate definition applies to people who have relevant financial interests, which he doesn't, or is entitled to exercise power. He's not. He's out. He sold his shares. He has no position. So I would submit to the commission that those 4 prongs are clearly no longer applicable. He's not a qualifier under those 4 items. If you get to the 5th potential way to analyze whether or not he's a qualifier, we'd respectfully submit that doesn't apply either anymore. That's under Chapter 23K, Section 4. And that's the one referenced by Commission Counsel about whether or not the person is has a business association of any kind with the company. And again, that is a technical term, and we have submitted in our brief that that has been defined. That has been defined by the Superior Court in Massachusetts in the case that we cite by Judge Sanders back in 2013. The case is called Gibbons v. Galvin, and it's cited in our brief at page 5 at the top. And she defines, albeit analyzing a separate statute, but in the same context, that a business association would denote a joint enterprise or transaction between one or more individuals of a financial or commercial nature. That doesn't exist here anymore. Again, sold his shares, stepped down. He's no longer a qualifier under that prong. Finally, you could get to the 6th potential way to assess whether a person's a qualifier, and that would be the catch-all provision found at 14H of Chapter 23K. And that pertains only to people who can exercise control or provide direction to a gaming licensee. Again, here, he's lost his capacity to control or direct this company. And as such, under the law, he has no right to be deemed a qualifier. And we think both the facts that we have submitted to date and the law, he should not be considered a qualifier. And that we respectfully submit that should be the Commission's conclusion. Now, there's one point I want to make clear. The company counsel alluded to it, said he won't be voting his shares, and that might seem like a curious statement given that he has no shares, right? But there is kind of an unusual quirk in the corporate law, which is, I can best paraphrase it, is this, that when a corporation calls an annual meeting like this company has done for May 16th, they have to set what's called a record date. The record date is the date where anyone holding shareholders as of the date is on that list. Okay, and the reason I say it's kind of a strange quirk in the corporate law is that after the record date, but before the annual meeting, sometimes people sell all their shares. That's what he's done. He's out. He sold all his shares. However, as a technicality under the corporate law, he could, if he so chose, and he doesn't so choose, vote his shares. That's what company counsel was alluding to with respect to he doesn't intend to vote his shares. A, he doesn't have them anymore, and B, under this little gap in the record date and the annual shareholder meeting timing, he's not going to vote his shares even if he wanted to. So I wanted to make that clear to the panel.
That's what you're referring to in your footnote on page 3 of your brief?
Yes, sir.
Yeah, okay.
Yes.
Is there any legal prohibition in him exercising the proxy share vote?
No, I don't believe there is.
So he could, in theory, despite his representations that he's not,
And
vote
that's why
on May
I bring it to your
16th?
attention, yes. That is the corporate law. But he has no intention of doing so. He's conveyed that to the company. And if you want to make whatever decision you make effective as of the date of the annual meeting, May 16th, then there's no technical gap at that point.
Does he have any intention of attending the annual meeting?
No.
Would you know?
He does not. So that, I think, is the applicable legal analysis. I agree that the separation agreement that has been discussed that was entered into on February 15th is an important document. It makes it clear that he's got no more duties and no more responsibilities to the company and vice versa. It also makes it clear that he has no further authority to act on behalf of the company. And he didn't get any severance, and as noted, to the extent he was allowed to live on the property until June 1st, he's already gone. So for those reasons, for the reasons that have been discussed by everyone else, and based upon the facts in the record and under the law that applies to qualifiers, we'd respectfully submit that the commission would take this under advisement and issue an opinion ultimately which concludes the same thing. He's not a qualifier. So going forward, if there's issues that the commission is concerned with, it should be addressed with the company, not Mr. Wynn.
Questions, issues?
I don't know if this would have been a question for the company, but let me pose it to you, and I can always come back to Council Sinatra if needed. There was, as part of the separation agreement, there was a registration rights agreement relative to how they could sell, Mr. Wynn was going to be able to sell the stock when he did so. Originally, it was, the agreement provided that there was a sale restriction of 1/3 of the shares per quarter. But is it correct that the company must have waived that provision for him to be able to sell those shares prior to those quarters?
I don't know all the nuances of the sale itself and who had to waive what. All I do know is he sold 100%. He's got nothing left.
Is that your understanding too, Ms. Sinatra? Okay. Would you mind?
Why don't you come up?
Please come up if you don't mind.
As part of a separation agreement, Mr. Wynn was granted registration rights. Most of his shares were unregistered shares because they were pre-IPO shares. And so they were not tradable freely on the exchange. And so we agreed, subject to some sales limitations. And the reason that the sales limitations were negotiated in the first place is that we wanted to be sure that there was an orderly movement of those shares. And so we didn't go out and dump 12 million shares on one day, which would have really destabilized the company. He ended up being able to sell the first 4 million shares that he sold. And I'm sorry, I don't want to give you a tutorial on the securities laws, but under Rule 144, which did not require the exercise of those registration rights. We then registered the remaining 8 million shares, and they were sold on a registered basis to both Capital and to T. Rowe Price. And so the short answer to your question is, yes, we waived the restriction because the sale was orderly. That's been fully performed.
Mm-hmm.
And so that portion of the severance agreement has been fully performed.
Ms. Sinatra, while you're up here, did I understand Mr. Maddox's story right? It sounded like he was talking to Wynn about selling the shares and said he didn't want them to sell them to hedge funds and some kind of a category of buyers, and Wynn immediately went out and sold a bunch of his shares to precisely the people Mr. Maddox had asked that he not sell to. Did I understand that correctly?
I think that is a relatively accurate précis of what Mr. Maddox testified to. Mr. Wynn was, and we were eager for him to fully divest from the company, and the negotiations took a little bit longer than maybe he wanted them to. And so he did sell 4 million shares in advance of the placement to the long-term investors.
Does that suggest an adversarial kind of relationship between Wynn and Wynn Resorts at this point?
It's been difficult. It's been very difficult.
Anybody else? We talked about this vague kind of relationship that possibly could come in under the 6th category about based on his long-term relationship and the force of his personality, that he might be able to exercise influence over certain members of possibly the staff or of the board. Does he have any interest in that? Can you speak to, others, the commission, the people at Wynn Resorts have talked about testifying that they will not be in contact on any substantive matter whatsoever, and that there's going to be a formal process in place to record any such any contact, including such substantive contact. Will he make similar representations? What's his frame of mind about that?
Well, he certainly has no interest in abandoning longtime friends, and they have no interest in abandoning him either. So to the extent he has long-standing friends in the Vegas area, he's going to continue to be friends with them. However, with respect to the actual legal standard is on that catch-all provision, it's whether or not an individual can exercise control or provide direction to a gaming licensee. And he hasn't done that. He won't do that to the extent the commission is concerned with what may result in the future. I think it could be satisfied with conditions upon the company itself to the effect of don't take direction from him with your business. I think, as you pointed out earlier, it's pretty hard not to bump into people you've known for 30 years, et cetera, in your local community.
To that end, there are a number of projects, let's say, a lagoon in Las Vegas, a property across the street that Mr. Wynn envisioned the project. Do you foresee any kind of contact to the effect of what was envisioned for those projects? Ms.
No, we really don't. And so, and part of probably the process that wasn't always apparent to the public is Mr. Wynn always worked with a large number of creative collaborators. And so he may have been the conceptualizer of many things that our company executed upon. There are a great number of creative talents new ones that we've recruited, old ones who we continue to work with. But I think that management has really revisited all of those capital projects, reprioritized some of them, and so I do not envision Mr. Wynn participating, frankly, at all with respect to those matters.
Anybody else? Sorry, anybody else? Okay, I think we are then finished. We have the opportunity, we have offered an opportunity to either or both parties to do sort of a summary wrap-up, if you wish.
Or not.
I think you may have heard enough from me. My view is fairly straightforward. He's not a qualifier. Neither the law nor the facts that you have support any decision otherwise, and we respectfully ask you to so rule after you've conferred amongst yourselves.
I believe that the company rests upon its brief and testimony and documentary evidence. Thank you.
Great. Thank you all very much. We will now, as long as nobody else questions or issues, we will adjourn as our practice has always been when there's any kind of an adjudicatory process with any controversy. We will adjudicate in private, and we will report out as soon as we can with a written decision on our deliberations. And I guess if it's is this a temporary adjournment, or is this I'm closing the hearing, so I guess I need a motion to adjourn.
Move to close this hearing.
Second.
Any discussion? All in favor?
Aye.
Opposed? The ayes have unanimously. We are adjourned. Thank you very much.
Thank you.